that power must be exercised reasonably and rationally. So he couldn't override it without a very good reason to do so.
Former President Jacob Zuma's medical parole is being challenged in the High Court by the NGO, the Helen Suzman Foundation. Joining me to discuss the nature of this legal challenge is Helen Suzman Foundation legal researcher, Chris Fisher. Chris, welcome back to the CRA channel. Could you tell our viewers what is the nature of the application that you're making to the High Court?
Well, in the first instance, we are seeking the record of the Commissioner's decision to place Mr. Zuma on medical parole. We had initially written to the Commissioner requesting these reasons in an effort to determine whether or not the decision was made lawfully, but the record wasn't forthcoming. So we've now made the assumption that it's not going to be forthcoming, absent some sort of order from the court. So in the first instance, that's what we're seeking: the record of the decision, the reasons, and the documentation that support the above. And that's so we can facilitate a proper review of the decision to determine whether or not it was made within the Commissioner's lawful powers.
And according to your view, do you think that the Commissioner, Arthur Fraser, acted within his mandate, within his prescribed powers?
Well, the answer to that question lies somewhere in the record. So, and that is part of the problem here, is that we have been greeted with a process that's shrouded in secrecy. The public information we know, particularly to the extent that the finding of the Medical Parole Board was sidelined, it doesn't bode well for the lawfulness of the decision. But that makes transparency in this case all the more important. So we can see what really went into the decision, and make an informed call from there.
Okay, so once you have the information that informed this decision, you're also seeking to review the medical parole that was granted to Mr. Zuma. How would that play out in terms of the legal process?
Enjoying this analysis? Click here to sign up for our 30-day free trial for more content from the CIA.
Well, with the record in hand, we would be able to determine whether the powers were exercised lawfully. And there's sort of two lines of legal argument that become relevant once the record has been disclosed. The first is whether the Commissioner has the power to override the Medical Parole Advisory Board in granting parole, because the decision to place an offender on medical parole is a composite decision. There are various factors that go into it. Only one of them is medical. So the initial argument is the initial exploration of the act is to say, well, does the Commissioner have the power to override the medical aspect of that decision? And we contend not in the application. We contend that his expertise is about the correctional services aspects of the decision, and where there is a finding against medical parole by the board, that should rise to a fundamental input into the decision. But if he is able to find a power of override somewhere in the legislation, that power must be exercised reasonably and rationally. So he couldn't override it without a very good reason to do so. So those are the two legs on which the lawfulness of the decision can be tested, and both just require the record. Both require us to see exactly how the Commissioner treated the advice of the Medical Parole Board.
In the weekend's newspapers, there was a report that Mr. Ramaphosa, the president, had, quote, green-lighted the medical parole of Mr. Zuma. Is that a presidential power? Do you think that this is just media speculation at this point? Does the president actually have that power to grant parole?
Well, in terms of our application, we are leaving that as speculation at that point. I don't think it's risen to a status of proven fact just yet. But the Commissioner certainly has to make his decision independently. There can't be any dictation from above or without in terms of directing him one way or the other. So the short answer is that the Commissioner must act on his own in making this decision if it is to be lawful.
One of the arguments that's been made by Mr. Zuma's legal team is that any requests for clarity on his medical condition essentially amount to a violation of his privacy rights. How will you be treating this in terms of your legal strategy going forward?
So it's inevitable that a record like this will contain some sensitive information. And despite the clear value of transparency and the inherent in this issue, Mr. Zuma is entitled to make out a case for certain of his documents to remain confidential. And the HSF is perfectly open to a confidentiality regime that keeps the information between the parties to the litigation, in an effort to just appropriately balance Mr. Zuma's privacy rights with the public's interest in having this matter properly reviewed.
And in terms of the next steps from here, Chris, how long do you foresee this process taking? When will you receive judgment from the court on your review application?
Well, it's very difficult to tell from now. The papers were filed yesterday, and part of what we've asked the court to do is to set down an urgent timetable for the review. So some of the timing aspects are out of our hands at this point. So we do hope that it'll be dealt with expeditiously. But as we have seen with litigation on this matter in the past, we should really be prepared for, we can be prepared for a lot of unexpected twists and turns, I'm sure.
Chris Fisher, thank you very much for joining us on the CRA channel. Let's hand over to you, our viewers. Do you think that Arthur Fraser acted appropriately and within his legal mandate when he granted Jacob Zuma medical parole? Let us know your thoughts in the comments section below. My name is David Ansara. This is the CRA. Until next time, take care.